first joined the court in Victoria and came over to Western Australia about 10 years ago, I undertook work as a lawyer for applicants in native title proceedings, both in Victoria and in Cape York. So that's my background. So unlike Julia, I do have a bold streak in me sometimes where I do go then to sort of suggest some options of thinking about, but when I start, I say that from the background of genuinely having thought about it and having worked in the area and worked in an interdisciplinary way with anthropologists. So for me, this question is a broader question. So I just keep that in mind in case, and I would invite you to ask questions once we're into questions, because that may clarify things if there's misunderstanding. So I just firstly, because I've only joined your conference today now, I just wanted to acknowledge the traditional owners of this land, so that's the Whadjuk people of the Noongar Nation. And I also just wanted to confirm, I'm here and I've been asked to come on behalf of the court, and the court asked me to come, but my views are my own because it comes from my understanding and my work. So I haven't gone to anyone and checked this is exactly the court stance. So I just say that as a disclaimer because I would hate for anyone to think this is what the court thinks. So in terms of the lack of availability of anthropologists, from my perspective, this has been an ongoing tension about the limited resource of expertise and how this is addressed and how succession is possible. I met David Trigger a while ago now, I was a lot younger, and I was educated about his approach to trying to get more junior or anthropologists in the university sector working in the native title area. Similar issues, in some ways what Julie was talking about in terms of some of the critical issues of no career path, burnout and moral hazards are something that are experienced. I think there is a shared experience with people who have worked in representative or service providers, native title service providers. So I just note that in terms of when Julie mentioned maybe there are connections you can make to these issues. I do think that there are synergies in relation to those issues when you're really committed to the area. So there are similar issues, and in the law, I was thinking about it in terms of junior barristers. We now have the court trying to give more junior barristers, and that's counsels, more opportunities before the court with the support of more senior people they're working with. And so how do you do this with anthropology? So that's a question I was asking myself yesterday and today. I think it's important that ideas and possible solutions firstly come from anthropologists who've worked and are working in the area. That's because you have a better understanding regarding applied anthropology and the challenges and opportunities. This issue is more than just about native title, and I recognise that. It's about anthropology work that's being done, anthropological work that's being done that is interrelated sometimes with cultural heritage work and other community-related projects. So when anthropologists sometimes work with community, there are other things that just come up and people do. So noting this, however, noting that yes, the solution should come from you, I have thought through what solutions may be possible. And I do think that the approach that has been taken, and there's David, there's David and David, I forgot they're both Davids, there's other people, there's Kingsley, I think about around here, and I think that approach of bringing newer or more junior anthropologists working with senior anthropologists, just like we do in the court, you may not see it, but behind the scenes, like Trinity and I were talking about behind the scenes, at the court there's a lot of behind the scenes. I've been lucky to be one of the people behind the scenes who've been able to work with judges and get a better understanding about their work and learn about the law simply by being in their presence. So I say that because there's David, there's Kingsley, there's other people here who have worked with more junior anthropologists. The question becomes how you keep them in the system, because some of those people I have noticed have left the system, and that is a broader question, but I just put that out there that I think one of the solutions does lie with more senior anthropologists working with anthropologists. This may include, for native title purposes, working together on initial research for an application. may include authorisation, may include registration material, connection material, and ultimately expert evidence reports. Sometimes it may not be possible for all of that, but I'm simply sort of starting to advocate for there needs to be work, and when work arises, thinking of a more senior anthropologist and a more junior anthropologist for succession. Now, I think ultimately where the court is involved, there are various tensions, like everybody knows. There are tensions about what the court expects, and then the applied anthropology and your own profession and what is expected. And so what I thought I would do just in my understanding of things and my seeing of the tensions is just to name some of the tensions, to think about, well, if there's going to be solutions, these tensions are there, and how do we actually try to work through them? So I'm trying to, and this is from my perspective as the court hat on, there is a tension between the court, and I think Kingsley and others have engaged with this, about the federal court's expectation that expert witnesses, which we call the expert anthropologists or expert witnesses before the court, are independent, provide impartial evidence on his or her experience, are not pressured or influenced to conform to a party's interest, and what a witness retained by a party for the purpose of preparing a report or giving evidence as an opinion is wholly or substantially based on their specialised knowledge as a witness. So it's a lot of words. The court's harmonised expert witness code of conduct, containing the expert practice note on the court website, states duties to the court. So an expert witness is not an advocate for a party and has a paramount duty overriding any duty to the party, to the proceedings, or other person retaining the expert to assist the court impartially on matters relevant to the court of the expertise of the witness. So one of the tensions with all those words that arises relates to where newer anthropologists, say like, not to pick on Trinity, but say like Trinity are in-house at native title representing bodies or service providers. I have to be honest, when I worked at I can think of various, but when I worked at a rep body, I too was employed by the rep body, but that didn't mean that I didn't think I was independent. In fact, I asserted it a lot. But how do you bring that person into the work without tension arising regarding their independence and impartiality? So how do you do that? I don't think it's necessarily impossible, but I do think to ensure there is a clear ability to show the anthropologist is independent and is providing an opinion based on their own expertise. So one way that I've come across that it has been done is where the in-house anthro, to complete the work independently outside the in-house work, becomes a consultant undertaking the work with the senior anthropologist. So basically tries to separate working at the representative body to make it possible for them to undertake the work without the criticism that may come from the court. So that's one option. This has worked before, but again requires real clarity about the expectation of expert witnesses and obligations to the court. Where it is not possible to do this, and I would encourage thought about who is engaged as an expert witness, because we do have examples where judges have been critical of in-house anthropologists undertaking work and the question about impartiality. I'm not suggesting that it was right, but I'm just suggesting that those issues have arisen. So another tension that arises relates to informants and connection material and reports. There are now quite a few judgments and more recent judgments from some of the judges who've more recently been in native title that are critical of expert witnesses and opinions which appear to the court, rightly or wrongly, to be inconsistent or disconnected in some way with Aboriginal evidence given in the proceeding before the court. So what happens is we have senior anthropologists who've worked with those communities before, who have engaged with many different people as informants, quite rightly, but then, okay, 5 minutes, but then the court is critical that the Aboriginal evidence they've heard in court, which is very hard to give in any case, does not connect to what the judge is hearing. So we have some cases like that. We have Punalulu, we have some in Western Australia, and this is an issue. So how the judge weights the evidence is his or her responsibility. That is under the Constitution their responsibility. But this tension, this is a tension it's important to be aware of, It's one of the reasons in Western Australia we've got some hearings next year where the judge will be pushing, there is a judge who is pushing to hear the Aboriginal evidence first. The advantage of that is that the experts would attend the hearing, and then the anthropologists, experts, the anthropological experts, would then give an opinion on that evidence. So it gives a clearer way for the anthropologist to also give views on the evidence and be less criticised for engaging, because you may have talked to other people and it may be okay, but to get the consistency of the Aboriginal evidence when you're listening to it for a judge is very, very important. So there's also the tension relating to connection material produced in mediation. So I do a lot of mediations, and when Julie was talking about some of the issues to do with colonisation, I struggle in some of the mediations I do in relation to the sadness that I get hearing, particularly in all parts of Australia, but I do a lot of work in Western Australia and Victoria and in highly settled areas, the effect of colonisation. It is hard. And I think that it's something we need to be aware of. It's something that we can't deny, and we need to talk about in terms of how it affects us, because there's great sadness. There's been things that have really happened that people have come up to me. I mean, I've contributed to maybe, but I've said congratulations, and on that day I felt really sad because I knew what was behind it, and I knew the sadness of people, and that was what drove me, but it made me really sad. So I think for expert witnesses, it is important to think about, if you're doing work for mediation, because there are people who have been involved in mediations, probably in this room, who have assisted actually settle proceedings. That's what anthropology does do as well. In various proceedings I've worked in Western Australia and Victoria, the contribution is high, but understanding that those reports may need to be redone in terms of form for any expert for any trial. So there is that tension as well. Like, you produce a report and you think, yes, Ann Daniel, this is ready for a trial, and I come back to you, say we were working together, and I say, well, actually, you're going to have to go back, and there are these requirements of the court. And so there is that tension of sometimes what the court requires and what you may think, well, I know better than the court. So there is that tension. Another tension is timeframes. So I've been known to put some timeframes on people in Western Australia. When I came over here, that was my job. I think in that context, in terms of timeframes, one of the things we really worry about, it wasn't that we wanted to be mean, or I wanted to say this has to be done by now, and I just wanted to use power. What it's about is a real concern about, because I think it's sometimes misunderstood. People feel like you're just saying, do you? Yes, you do. I know Ray Wood, he's not here today, but he's always having a go at me. I think one of the concerns, and people take it deeply personally, and that's actually not what it's about. A lot of those times, those time frames have been thought about understanding the Aboriginal evidence that may be lost and what that will mean. So I don't know whether some of you may be aware, I can see Josh at the back, he knows. I did a mediation for about 3 years in a proceeding in the Yamaji area, which is now finished, so I can say it, where it went down, it didn't resolve, and that was okay. That wasn't really why I was doing it. I was doing it to generally contribute understanding the preamble of the Native Title Act. But when it went down, I was very, very upset, and a judge, the judge who's now the Chief Justice, said to me, oh, and why are you upset? Because, I'm not a tick in the box kind of person. I'm not someone who's just there at the court trying to have fame. I was genuinely concerned that some of the evidence had been lost by a mediation process that had gone for 3 years, and I myself had thought that it would settle, and then I understood it wouldn't, and I knew some of those people, and I knew they'd passed. They were they were old pastoral, like they worked on pastoral stations, they knew their country, and they're gone, and they're slowly gone through this 3 years. I could name them, I can still name them. And so that found its way to resolution, which is a good thing, but at the same time, I think I just wanted to put that in because I know that's a tension with the court, that often we're asking for timeframes and we're not just doing it for power. We're doing it because we see a bigger picture at times, like I do at least, and I'm thinking, what about if this doesn't work? What's going to happen to that evidence? And is that justice? Is it justice that people don't get to give their evidence? So I just wanted to say that while I was talking about the tensions. Yes, 1 minute. Another tension is the time. Yes, I've done that one. Okay. And you started making me more nervous. Now I'll circle back to availability of anthropologists. I may just skip some of what I was going to say because I thought this would take 5 minutes. For me, I'll just be very quick now, 30 seconds. For me, I've worked in this area. I've worked in partnership with anthropologists. I mean, I don't love them, but I love working with anthropologists. Native title is an interdisciplinary area. I've learnt a lot. Like when I say the Davids, all right, when I say Kingsley, that report last time, he taught me a lot. We do learn a lot. And so what I was putting forward very quickly is I do think noting that the Native Title Act is beneficial legislation, which means it's designed to provide benefits. So me working in the court, having worked with applicants, is that biased? No, because I say the Act is beneficial, so it's supposed to find things, and it's supposed to find those things like Section 87, ongoing connection. So one of the constructive ways I think that it would assist to start to engage with this further is for some sort of working committee to be set up, including junior and newer anthropologists, in-house anthropologists, and also representatives of law like myself and others. I'm not advocating I should be involved, but I'm just putting forward that I actually think we do need to, so taking what Julie said, start to really engage quite quickly about this while we've got those senior anthropologists around and we have more senior people in the law as well, the judges, not only the old anthropologists, the judges who get it. I think we do need to, and I think we have some experience now, and there may be some here of in-house people who've gone out and done consultancy work. So I can think of some people, Olivia Norris, other people who I've engaged with, who we can learn what were the challenges with doing that, how did it work, did it work, using data that you've definitely got, Julie, from all the work that you've done, to kind of really engage with this in a targeted way. Because I think if we don't start, we're going to be there's going to be real issues. And when we look at the statistics of the court, most of the matters before the court are First Nations groups and different First Nations group asserting rights over the same area. And so with that, I think that we need, because I worry that mediation won't be possible, and some of the mediated outcomes wouldn't have been possible unless those people came forward to undertake the work. So that's all I wanted to say.